How long can the police keep you at the side of the road? Not why they can stop you, how long they can hold you once they have. Just after midnight on a dark Nebraska highway, a driver drifts onto the shoulder for a second, and a patrol car lights up behind him. The officer checks his papers, writes a warning, hands everything back. The stop is over, its business is done, and then nothing moves. No one tells the driver he is free to go. He waits. 7 minutes. 8. A second cruiser rolls up. A dog begins to circle the car. And the whole night turns on a question the Supreme Court would take up 3 years later. Not whether the stop was legal, but whether it lasted too long. We spend a lot of energy arguing about when the police can pull you over. This case is about something quieter and more personal. The clock. Once an officer has a reason to stop you, how many minutes does that reason buy? Can they finish the ticket, then keep you sitting there on a hunch while they go looking for something else? In 2015, in a case called Rodriguez v. United States, the Supreme Court drew a line, not in space, but in time. Over the next 12 minutes, a traffic stop that ran a few minutes too long. The weight the court hung on a single word, mission, and why those 7 or 8 minutes still shape every stop on every road today. Just after midnight on March 27, 2012, Dennis Rodriguez was driving a Mercury Mountaineer down a Nebraska highway when it drifted onto the shoulder for a moment, then swung back. That was enough. Under Nebraska law, driving on the shoulder is a violation, and an officer named Morgan Struble was watching. Struble was no ordinary patrolman. He was a K-9 officer, and riding in the back of his car was a trained drug detection dog. What happened next was, for a while, completely routine. Struble pulled Rodriguez over, walked up to the window and did the ordinary things. He collected the license, the registration, the proof of insurance. He ran his checks. He asked the usual questions. Then he did the thing that, on paper, ends a traffic stop. He wrote Rodriguez a warning, not even a ticket, just a written warning, explained it, and handed the documents back. Stop and notice what that moment means. The reason for the stop was that the car had touched the shoulder, and Struble had now dealt with it. The warning was written, the papers were returned. In the language the court would later use, the mission of the stop was complete. By any ordinary understanding, Rodriguez was now free to drive away. He wasn't. Struble never said, "You're free to go." Instead, he asked for something more. Permission to walk his dog around the car. Rodriguez said no, and that refusal did not end the encounter. It started the clock this whole case is about. Because Rodriguez would not consent, Struble ordered him to shut off the engine, step out, and wait by the road. He radioed for a second officer, and for the next 7 to 8 minutes, Rodriguez stood on the shoulder of a dark highway, no longer being ticketed, no longer processed for anything at all, simply held. When the backup finally arrived, Struble retrieved his dog and led it around the Mountaineer. On the second pass, the dog alerted, and a search turned up methamphetamine. From the first flash of the patrol lights to that alert, about 29 minutes had passed, and what the search found came in the stretch of time after the warning, not before. So here's the hard problem. Everything Struble did up to the warning was clearly legal. Stopping a car that drifts onto the shoulder? Legal. Checking a license? Legal. A dog sniff on its own, the court had said in an earlier case, is not even a search. Each piece by itself was fine. What turned this into a constitutional case was the order they came in and the gap in the middle. The officer finished the traffic stop, then kept the driver there, with no ticket left to write, waiting for a dog. The government's answer was, in essence, what's the harm? It was only 7 or 8 minutes. Officers, it argued, should have a little breathing room, a small buffer to run a dog around a car, especially with a second unit on the way for safety. A few extra minutes is such a small thing, the government said, that the Constitution shouldn't even count it. In legal terms, it was de minimis, too slight to notice. And that argument has real force. 7 minutes is not long. If you have ever idled at a red light or in a drive-through, you have surrendered more without a second thought. Why should a brief, careful delay, done partly for the officer's own safety, suddenly count as a violation of your rights? On April 21st, 2015, the Supreme Court gave its answer, 6 votes to 3. Justice Ruth Bader Ginsburg wrote for the majority, and her reasoning turned on that one word, mission. A traffic stop, she wrote, is a seizure. For those minutes, the government is holding you, and it is justified only by its purpose. The stop exists to handle the violation and the safety concerns that ride along with it. Checking your license, your registration, your insurance, whether there are warrants out for you. Those tasks are the mission. And the authority to hold you, the court said, ends when the tasks tied to the traffic violation are, or reasonably should have been, completed. A stop may last as long as its job takes, and no longer. A dog's sniff is not part of that job. Sniffing for drugs, the court noted, has nothing to do with keeping a car safe on the road. It is a different errand entirely. Ordinary crime detection aimed at finding evidence. So when Struble held Rodriguez past the warning to run the dog, he was no longer doing traffic stop work. He was doing something else on the government's initiative, with the driver's time. Then the court did the thing that makes the case famous. It refused to let the outcome hang on the order the officer happened to choose. It would not matter, Ginsburg wrote, whether the sniff came before the warning or after it. One thing mattered. Did holding the driver for the dog add time to the stop? An officer cannot bank the minutes he saves by working fast and then spend them on an unrelated investigation. A stop, she wrote, quoting an earlier case, becomes unlawful when it is prolonged beyond the time reasonably required to complete the mission. And that is why the government's "it was only a few minutes" argument lost. The court refused to measure the intrusion by whether it felt big or small. The question was not how long the extra delay ran, but whether the officer had any authority to impose it at all. Once the mission was finished, he did not. 7 minutes past the end of a stop is still 7 minutes the government had no reason to hold you. It is worth being precise about what the court did not do. It did not ban dog sniffs, it did not ban traffic stops, or order officers to rush, or say the police can never act on a hunch. And it did not set Rodriguez free. In fact, it left a second door wide open. If Struble had a real, specific reason to suspect Rodriguez of something beyond the traffic violation, genuine, reasonable suspicion, then holding him for the dog might have been perfectly lawful. So the court sent the case back to the lower courts to answer exactly that. Setting the timing rule aside, did the officer have independent grounds to keep Rodriguez waiting? The dissenters thought the answer was plainly yes. Justice Clarence Thomas, joined by Justice Samuel Alito, argued that the whole encounter, all 29 minutes, was reasonable, and that the officer had enough to justify the wait regardless. Alito added that the majority's rule was strangely formal. An officer who paused to call for backup before running the dog, a sensible safety step, would now be penalized for the timing. Their point was not that time doesn't matter. It was that a short, careful delay by a lone officer at midnight was reasonable, which is the very thing the Fourth Amendment asks. But the majority's line held, and its strength is that it is clean. It does not ask a judge to guess whether a delay felt long or short, or whether a hunch was strong enough to be worth a few minutes. It asks a simpler question. Is the traffic stop still doing traffic stop work? The moment the mission is finished, the clock stops, and holding you any longer needs its own reason. That rule now sits behind millions of ordinary stops. Every time an officer finishes a ticket and then lingers, one more question, one more check, a slow walk around the car. Rodriguez is the case that asks the quiet question underneath. Is the mission over? Because if it is, the time that comes after belongs to you. So go back to that dark shoulder in Nebraska, just after midnight. The warning was written, the papers were handed back. The reason for the whole encounter was finished, and still the driver could not leave. The Supreme Court looked at those 7 or 8 silent minutes and said they were not the government's to take. Your rights, it turns out, are not only about where the state can go, they are about how long it can keep you. And that is the thread running quietly through all of this. 3 times now, we have watched the law draw its line in a different place, around the home and the walls that hold your heat inside, around the person and words spoken where no wall stands at all, and now around time itself, the minutes at the side of a road that no one is entitled to take from you. the same idea keeps surfacing in a new disguise. Your freedom lives at the edges, in exactly the places the state would find it easiest to slip past. We call the Fourth Amendment a wall around your private life, but it may be truer to call it a line, drawn sometimes in space, sometimes in sound, and here in time. Wherever it runs, the task is the same, to mark the point where the government has to stop and you begin. That is where your rights have always lived, right at the edge.